Good morning. Council is convened for a couple of work sessions this morning. September 17th, 2025. We'll start out with a SEPA review process and welcome Maya and Brent.
Thank you. Good morning, Council. My name is Maya Bunch. I'm the Interim Director in Community Development, and with me here today is Brent Davis. He's our Land Use Review and our Wetland Habitat Review Manager in ComDev. We're here today at your request to provide information on SEPA, the State Environmental Policy Act. This presentation is purely informational. And our intentions with this presentation is to explain what SEPA is, what it does, and also to explain the general process and what that process looks like in community development, specifically when we have a SEPA determination as part of a development application. At the end of this presentation as well, there are some links. One of them is the SEPA handbook. It's a 60-page document, lots of information in it. So if any more information is needed, that's a great resource. I'm going to pass it off to Brent now to go through our presentation material. Thank you.
Good morning, councilors. So I'm going to start out talking about what SEPA is and what it's intended to do. It is a process that ensures that government agencies consider environmental impacts for proposed actions before making a final decision. It's a procedural requirement for all state and local governments in the state of Washington. And it was established in 1971. You can imagine at that time, local government didn't have a lot of environmental protection in their codes. And so, it was intended to essentially be sort of a backstop for those things that weren't being addressed at that time in code. And it has evolved over time with GMA as a result. It applies to all project and non-project actions that the county does, unless they're explicitly exempted in the WAC that governs the SEPA process. I'll go over some examples of that later. Process ensures coordination between our agency and other agencies with might have jurisdiction over the same action, as well as organizations that may have an interest in the outcome of whatever decision is being made. It requires the lead agency, which is the agency that is essentially in charge of the process, to make a threshold determination for each decision that's subject to SEPA as to the probable environmental impact. And if we make a determination that there's a probable significant adverse impact, it triggers a requirement to do an environmental impact statement before the decision can be made. In the Act, there are requirements for information submittals. There's requirements for public notice and timelines associated with those notices to collect public input and input from other agencies. Next slide, please. So when is SEPA required? It's any time that we take an administrative or legislative action that constitutes a final decision, we're required to consider SEPA. Generally speaking, this includes permit approvals that we do in community development. Other programs in the county that issue permits may also be subject to SEPA if their actions are not exempt. It applies commonly to capital projects, in addition to code amendment efforts, as well as the comprehensive plan and changes to zoning. So in conjunction with the state regulation, we have adopted a local SEPA policy. It's chapter 40.570 in the county code, and that specifies our local procedures, informational requirements, and clarifies further when the exemptions in the WAC apply. So for any triggering action, the statute states that if there's a local government decision, that local government is by default the lead agency for the SEPA process. However, it does occur where multiple local governments may have jurisdiction over a particular project. And in that case, there's generally an agreement as to one of those agencies taking lead agency status. However, the law does allow for agencies to work together and create an agreement to co-lead, whether it's local governments or state and local. We had a project a few years ago where we did a co-lead with DHS, with the state, to ensure that both their needs and our needs were met through the SEPA process. Next slide, please. So getting into more details about the process and the threshold determination, the first step is preparing documentation, and then once the documentation is complete, issuing a SEPA notice. So the documentation generally consists of a SEPA checklist, which is a document we get from the state. It's basically a required form. And then in addition to that, there's generally supporting documents, which can be project plans, special studies, technical reports, anything that supports or provides information about the potential environmental impacts of the action. And once we have all that documentation, we issue a public notice. It goes to the Department of Ecology, which is the state agency that oversees the SEPA process. And it goes to any other agencies that may have an interest in the activity, as well as to the public, in our case, through our standard public notification requirements in community development. And then that notice is subject to a 15-day comment period where we can collect information and comments from the public up until the point we issue a final determination, but legally we're obligated to provide at least 15 days. And technically we don't have to consider comments that come in after 15 days, particularly if they're from the public. If they're from an agency, we generally still have to consider those, but the minimum comment is 15 days.
I have a quick question here. Can the public or anyone ask for an extension of the public comment period? Is that a possibility?
That's not provided for in the statute or our procedures, but we're not precluded from doing so if we felt that that was appropriate, particularly if we were aware that some type of information was missing that should have been provided, that we can also renotice if we get new information in the middle of a process, if we think that warrants another round of comments.
The reason I ask is I think with some of the projects, there could be, it could be voluminous record that if someone in the public wanted to really sift through that and make thorough and thoughtful comments.
Certainly, and there, once you get into the EIS process, there are longer comment periods.
Okay, thank you.
All right, so once we've issued the notice and we've collected comments, we perform an analysis of the documents and the comments that we've received, and we start preparing our decision documents, which includes the threshold determination. And then once we make that determination, we send out notice of our decision to Ecology, any of the agencies that responded to the public notice, as well as anybody in the public that responded to the notice. So in terms of final threshold determinations, there are three options. There's a determination of non-significance, which basically means based on all the information we have, we believe that there's not going to be any adverse environmental impact that has not been addressed in the application. That doesn't mean that there may not be, that there are no impacts. It means that any impacts that might occur are being mitigated in some way sufficiently. We can also issue a determination of non-significance, a mitigated determination of non-significance. And that's a circumstance where we believe impacts that will occur can be mitigated, but the information that's been provided thus far does not fully address that mitigation, but we know what that mitigation should be, and we can condition it and require it as part of the decision. And lastly, is a determination of significance. And so this basically means we recognize in the information that there are likely to be significant impacts that are not mitigated, and we need more information about what those impacts might be, how extensive they might be, and what type of mitigation might be appropriate. So that's what the determination of significance is. And that triggers an environmental impact statement, which is the process that we go through to get all that extra information and come to a decision.
If there was an appeal under number 3 here, would that then go before a hearings examiner? Is that the
In our process, that is correct.
right? And that has its own
Yeah,
timeline
yes.
for that.
Oddly, in the statute, there's no appeal process specifically specified. And that was one of the reasons we partnered with a state agency on a previous project, because there was a desire to appeal the SEPA that they had done on their own, and there was no pathway for appeal. And so we agreed to partner with them, essentially go through the process again and provide that appeal opportunity.
Thank you.
So once we've made a determination of significance, that starts a process which is called scoping. And that's another public comment period where we gather information about what the extent of that EIS should cover, what topics it should cover, what alternatives should be considered in that analysis. And I can get more into those details in a couple of slides. Next slide, please. Actually, I'm sorry, it's the next slide. So yeah, going through that scoping process, it's actually a 21-day comment period, which again could be a little short for a very large project, but that's what the statute requires. And again, we have flexibility. If we determine it might be appropriate to take longer, we can. So collect information from those parties on suggestions regarding scoping. And once we have come to a decision on what the scope of that EIS process is, it starts the process of drafting what's called a draft environmental impact statement. And so that, is the document that will address all of the items that are in the scoping decision. And again, we get back to looking at the threshold determination. Does the draft EIS address all of the impacts, and can the project move forward? Once we have the draft, that goes out again for public notice and is subject to a 30-day comment period before we can make a final decision and issue a final environmental impact statement. And also procedurally, once we get comments on a draft EIS, we have 60 days to get to that final decision. And that final decision also has to be made within 1 year of when we issued the scoping notice. So once we pull the trigger on an EIS, we're on a fairly rigid timeline to get it done. Next slide, please. So in terms of SEPA in community development, under the statute, SEPA is pretty well integrated into GMA. As part of that, we are able to rely on our development code as being adequate to address a majority of potential environmental impacts. And specifically, if our code speaks to a type of impact, if it's compliant with GMA, we generally have to presume that it is sufficient. And because of that, we generally issue a DNS in conjunction with a land use decision. That's not always the case, but that's the typical path. A few other aspects under our SEPA procedure. In a development project that triggers SEPA will also trigger archaeological review requirements. I guess I shouldn't say it, at least through our process. So applicants are required to comply with the state law with regard to cultural resources. But once they trigger SEPA, we sort of automate that pathway for them. So there's criteria as to when a archaeological predetermination will be required that's based on the location of the action, as well as the potential impact it might have to those resources that we apply and determine if somebody has to do that study. And then when we issue our threshold determinations, that's done in conjunction with our decisions. So for our administrative decisions, it's part of the staff report decision that's issued at the end of our review. For our type 3s that go to the hearings examiner, it's part of our recommendation to the hearings examiner, and that's why we issue that recommendation 15 days prior to the hearing, so that the 14-day appeal period can run, and if we get an appeal, it can be heard concurrently with the land use application. So we aren't requiring people to do 2 hearings. As I mentioned before, in most cases, we are issuing a DNS because projects at the end of the day comply with our code. That doesn't preclude us from doing an MDNS or a DS. We have occasionally done MDNSs, generally in conjunction with some of our surface mining projects, because there are impacts that could occur that our code doesn't directly address. Those are things like noise, potentially air quality. There may also have been cases in the past where we get specific input from a state agency that they have jurisdiction, and we might do an MDNS to condition that they comply with whatever that state agency requires. We don't necessarily get into the details in that condition because we don't dictate what the state requires. The condition would just say you need to satisfy this agency prior to construction. In my experience, in the time that I've been here at the county, I've never seen us issue a determination of significance in conjunction with a development application. That, is more likely historically to occur with a planning action. An example is the recent surface mining overlay revisions. But that doesn't preclude us from doing that if we see a project that we believe rises to that level if we happen to be lead agency. So a project of larger scope, with multiple jurisdictions, it could be a potential.
Sure. Just a quick question. So how exactly, I mean, these are handled in-house with our own staff, the determinations?
Correct.
Okay, so my question would be, with something as unusual as a project that we've talked about with the transmission lines, where do you gain like there has to be an inherent ability to know how a typical project would go to understand what the potential impacts would be. So my question is that when it's something we deal with on such a rare occasion at the county, how do we make sure that we understand all of the potential impacts that could come from a project like that?
So we have several options within our fee structure and our code. If we have specific topics where we feel we don't have adequate expertise, we can contract consultants specific to those topics to give us review of those specific aspects of the SEPA record. It's not inconceivable that we could hire a consultant to essentially run an EIS. We would have to figure out how, probably in agreement with the applicant on how that's funded. With our special studies, when we do hire consultants, we generally pass that cost on to the applicant. It's the way our code is structured. But if we went to something of a bigger scale, we might have to treat it as a special item, and it might require some consideration up front. Plus, something of that scale would likely have to go to an RFP. So we would need to build time into the process to address that.
Great, thank you.
All right, I think that is everything. Are there any other questions?
Sure.
Yes, go ahead.
Yeah, this is a great overview for a lot of the actions that we take. It's an interesting historical note that SEPA was modeled after NEPA, which was passed 2 years before and signed by Nixon. That's an interesting factoid. But I thought we were going to talk today a lot about the power line proposal, which is I'm very interested in how SEPA interacts with that project. So I have a couple specific questions about that. I had heard that Skamania County possibly will be the lead agency for this, and I wanted to confirm if that is true and is what, as you understand. And if that is true, can we share lead agency status or take it over or request to take it over just because it affects our county way more than theirs? And so that's question number one. And then two, on alternatives, a lot of the SEPA documents that I've reviewed and commented on have had more than two alternatives, the yes or no, the project or no project alternative. When is it required to have multiple alternatives beyond yes or no? And how would that apply to the proposed Bonneville power lines?
Well, we don't actually know anything about the power line project other than what's been in the public discourse. We have not been approached by Pacific Core, had any conversations with them. So I can't really speak to that. In terms of procedure, the statute does have language regarding who should be lead agency. We could certainly enter into an agreement if we got into a situation where there was some contention between who should be lead agency. That may have to go through some kind of adjudication or appeal process. But we also, under the statute, have the ability to claim lead agency status if we believe the current lead agency is not doing an adequate job. We would certainly have to defend that decision and could be challenged on it, could slow down the process. But that is provided for in the statute.
Okay, thanks. And I realized, did I just say BPA instead of Pacific Core? If I did, sorry, Pacific Core. So we do have the opportunity to potentially request being lead agency if Skamania County is the lead. And how would that request, how would we ask that? Would we ask that from the council level or the staff level? How does that work?
I think we'd have to look at it once we got to that point. Honestly, I've never been through that process, so I just know that it's provided for in the administrative rules. There's a procedure. I suspect that ecology would be involved since they are the state agency that is designated by the legislature to oversee SEPA. And then there has to be some kind of adjudication process if there's disagreement.
Okay. And as for alternatives, I assume if the only options out there is build the project or not build the project, those are the two alternatives. But if there are any other alternatives that are less damaging than build the project, that it is required by law to consider those a third or a fourth alternative. Is that correct?
That is determined in the EIS scoping process. And what the statute says is that we can ask for analysis of reasonable alternatives. And so we have to agree on what is a reasonable alternative. If as lead agency, we want to require an alternative to be analysis, we have to be prepared to defend that is a reasonable alternative.
Okay, yeah. And I've been curious for a long time since I've heard about this proposal on what a reasonable alternative would be and where other alternative existing lines exist. And if there is the possibility for extra capacity on those lines or lines adjacent to them in the same corridor that would be less environmentally damaging and less damaging to our community than the ones that are proposed. So that's my interest in asking these questions.
I just wanted to follow up on one of those questions. Could you provide us with the language related to a determination of who should be the lead agency?
Yeah, we can follow up with that. I
Great.
can, yeah, give you the, yeah, it's right in the WAC, so I can provide that reference and provide the language.
Perfect. Thank you. Go ahead, Counselor.
Just want to clarify. So you said that in the EIS process, we could ask for study of alternatives, but that's only if there has been a determination of significance, correct? You don't get to the EIS process without the DS. Is that accurate?
That's correct. Yes,
Okay.
until we get to that scoping process, there is no requirement for consideration of alternatives.
Okay. And essentially, I mean, theoretically, if they propose a project that shows mitigation for all identified potential impacts, then it'll be ruled a DNS, right?
Correct.
Okay. Thank you.
Now, generally, development requests don't come to the council for our approval. Is that correct?
That's
We would
correct.
be making decisions on zoning, things like that. So this particular request, should it come to the county, we may not even see as a council. Am I understanding that correctly?
If it's associated with development application, that is correct. Now, we can certainly, within the limits of SEPA, like, we solicit comments from interested parties. So, there may be an opportunity there to at least get some input.
Great, thank you. That's what I understood. Did you want to add anything to that?
Yes, Chair. Thank you. Steve Archer, Senior Deputy Prosecuting Attorney. I would like to address your question regarding, and questions regarding determination of lead agency. What I can tell you is I'll follow up with that to give you a description of the Washington Administrative Code regulations that apply to that. But I'd like to quote for you now, WAC 197.11.932, which provides that for proposals for private projects that require non-exempt licenses from more than one agency, when at least one of those agencies requiring such a license is a county or city, the lead agency shall be the county, city within whose jurisdiction is located the greatest portion of the proposed project area, as measured in square feet. For purposes of this section, the jurisdiction of a county shall not include the areas within the limits of cities or towns within such county. There are processes in here for lead agencies to, as Brent has explained, where there's processes for sorting this out. I wanted you to have that. There are more. I'm not giving you this as my final a statement of a conclusion, but I thought you should be aware of that regulation. Thank you.
Great, thank you. That's very helpful. Appreciate it.
Could I just dig in a little bit more? So based on that reading, would you assume that we would likely be the lead agency?
Councilor Little, thank you for that question. I am not prepared to give you my legal advice at this work session, but I will follow up with you and the council. I think that's a great question. Thank you.
Thank you.
Yes, go ahead.
If I may just shortly, I think your point was important for what is our role as a council, and I see it being, this is a project that has significant potential impact on our community. It's a big project, and it's an unusual project. So I think that it is our role in this point to ensure that the public are protected and that we advocate, ensure that we're in the decision-making process as a lead agency or co-lead, whichever that one goes. However, I do feel like, we're not really involved other than that. Where I do think we could choose to take some involvement, and I think we had discussed this and maybe requested, I can't remember how our previous conversation went, was taking a look at the existing code that affects this project and potential future projects and see if there needs to be any modifications with that. That is our role.
Good point. Thank you.
Chair.
Yes.
I actually have a general question. I don't know who may be able to answer that, staff or Christine, but why do development requests not come through council for approval, where in other jurisdictions like the city of Vancouver or other cities, that seems to be common practice?
Yeah, this is Chris Cook, Chief Civil Deputy. For many years now, it has been the code, the requirements of the code that what we call legislative actions come to the council. And those are things like decisions on the comprehensive plan and on what the code should be. However, development applications do not come to the council. In the past, appeals of development permit decisions came to council. And that brings up a whole range of issues that were just taken out of the picture by the change in code. And among those things is, well, if you're going to rule on an appellate question, have you read the entire record? I don't know how y'all feel about reading multi-thousand page or multi-hundred page records on a regular basis, but since you don't have to make those decisions, that is not your obligation. So we have a hearings examiner system, which is generally viewed as a best practice for having an impartial and evidence and law-based decision. So that's one of the issues. Another issue is that in legislative matters and other matters, you all are very regularly contacted by advocates with an interest in your decision. That's okay. You can talk to them. When what we're talking about is a quasi-judicial decision, a permitting decision, you should not be contacted ever by one side. And if you have been, you should disclose it. This is a rule that can be rather awkward in its application and misapplication. And again, questions about your compliance with those requirements are non-existent if you're not making the decisions. So this is a matter that is, this is a setup, the way we have it, that is absolutely in keeping with state law. And it's the charter. And so that's how and why the county does those things differently.
Thank you. I like the current process, so let's keep it. Thank you.
Chair, I would just add too that this is probably what you meant, but not all development applications go to the council in the city. It's really only development agreements. So when there's some variance from normal code where they're offering higher density amounts or some special condition that doesn't fit the normal code, that's when it goes to the council typically.
Thank you.
Are you talking about City of Vancouver Council? Okay.
most cities.
Any other questions? Comments from you all? All right. Thank you very much. Very informative. Appreciate it.